Shahid Buttar from the Bill of Rights Defense Committee. I'm going to share a little bit of context about the Surveillance State Repeal Act, and particularly try to explain a little bit about the context in which you're operating as you consider both this piece of legislation and the impending debate surrounding the potential reauthorization of the Patriot Act powers set to expire. And some of these are themes you've heard just now from my colleagues. Patrick mentioned that when the Patriot Act was first introduced, there was a rushed debate without sufficient transparency. That's also been the case each of the several times that the bill has been reauthorized. Further, when there have been rare, meaningful attempts at congressional oversight, executive officials under administrations from each of the major parties have outright lied under oath to Congress. And this is demonstrable. We know there were lies because we got documents since then. That's what the whistleblowers showed. I want to connect that to one piece of the bill. When whistleblowers inform Congress about lies being told by executive officials under oath and oversight hearings, it behooves Congress to protect whistleblowers to make sure that you are getting the facts. And at the end of the day, this is not only about constitutional rights and freedom of thought, I'll get to that in a second, but this is about your powers and the prerogative of your branch of government. If Congress is going to get lied to by executive officials and then summarily reauthorize powers, as it has done every time mass surveillance has come before this body, it is allowing its own power to check and balance the executive, to legislate with the full facts, simply to be told the truth under oath, to be eroded. So this is as much about institutional self-protection, I dare say, as it is about checks and balances, transparency, or the Fourth Amendment. Aside from there having been no meaningful process with respect to the transparency underlying these powers and a history, or a recurring history, of executive duplicity about not only whether or not these powers are efficacious, but even the mere scope of these powers, right? The authors of the Patriot Act discovered how Section 215 was being used, not from the Director of National Intelligence, not from the head of the NSA, both of whom they asked about it. They learned about it from Edward Snowden, and what they say is that they meant to create a very robust, targeted surveillance authority. And what the agencies contrived in secret, in violation of both the Constitution and the statutory background, was a pervasive dragnet, ambient, dragnet surveillance authority. And that's very different than the kind of reform that would promote public safety. Patrick referenced the 9/11 Commission's findings that intelligence collection was not the failure that enabled the 9/11 attacks. Yet we spent 15 years trying to solve a collection problem, right? So we're solving a non-problem while we are creating very real problems. And I want to dig in on those. And I'm going to explain a little bit about why mass surveillance is unconstitutional. And it goes not only to checks and balances, it goes not only to privacy, but this gets to the very freedom of thought and the opportunity for democracy. It's the reason that the founders embraced the First and the Fourth Amendments in the first place. When you have secret surveillance that is unreviewable, there are not only opportunities for abuse, but they become inevitable. We know, in fact, from at least 24 NSA operatives that the government's very powerful spying tools have been used in several instances, not to pursue legitimate national security threats, but rather to spy on the ex-wives and former lovers of NSA and contractor personnel. That is not a legitimate use of these powers. It is exactly what we can expect when they are allowed to operate behind walls of secrecy. And that gets to the potential chilling effect. These powers can be politicized in ways that are potentially terrifying, quite frankly, and the fear of general warrants that were not specific to the time and place were exactly what motivated the founders historically to insist on the inclusion of the Fourth Amendment when the Bill of Rights was attached to the original Constitution. It's not novel to require the government to specify who it will look like. It is well grounded in our constitutional tradition. It is inherent to being a free people. And it sounds like a very grandiose principle, but it's exactly the one put before your offices in this bill. You will hear from the intelligence agencies that mass surveillance has a sound legal constitutional basis. They will cite a 1979 case, Smith versus Maryland, which absolutely does not stand for the proposition that mass surveillance is legal. This is just a 90-second lesson about the case. That case was about particularly targeted surveillance of a particular person, of whom authorities, in that case in Maryland, had suspicion of involvement in drug transactions. It was over a limited time. So we had a particular individual with suspicion of criminal activity bounded by time. What we are talking about in the contemporary context is unbounded. It is the entire state, and indeed the entire state, and indeed the entire world. There's no suspicion of anyone required to come under the government dragnet, and we are talking about indefinite, constant surveillance. There's no relationship between the 1979 case and the contemporary mass surveillance paradigms, which is to say it lacks any legal basis. And the last thing I'll say is that while we often think of the courts as the constitutional guardians, your branch has an equal role to play in checking and balancing the executive. And as you're considering this bill and others that will come before your offices, think of it through that lens, asserting and maintaining the power of Congress to remain enacted.